I'm pleased to welcome all of you in the framework of this very interesting discussion, I guess. And the theme is forced landing in Belarus. All of us are fully aware of circumstances of this forced landing of a flight from Greece to Vilnius. And all the circumstances gives us the ground to believe that this was not accidental interception of a flight. So this was not accidental landing. And the main aim of this interception of a flight was to detain a few citizens of Belarus and the Russian Federation who are persecuted by the current Belarus ruling regime. And from the perspective of international or state practice, we can also say that this incident can be called as unprecedented, really, although, of course, we know that there were some instances of similar behavior. It was interference into free movement of international civil aviation. And therefore, we have a lot of, or a number of various issues, international legal issues, which could be considered both in the framework of civil aviation law. I mean, the Chicago Convention, the Montreal Convention as well. And because we have in mind also the purpose of this action, of this incident, namely, as I mentioned, to detain and to arrest later a few persons who were in opposition to the Belarus ruling regime. We can also speak about violations, possible violations, alleged violations of international humanitarian law. And we also know that a few states have already started criminal investigation into this incident on various grounds, both as regards freedom of international civil aviation and international humanitarian law. Therefore, in this event, we have a number of speakers with recognized authority in their field of research. And I am pleased to introduce, first of all, Associate Professor Miles Jackson, who is Associate Professor of Law at the Faculty of Law and a Fellow of Jesus College. He holds master's degree and PhD from the University of Oxford, LLM degree from the Harvard Law School. And he has a range of research interests in general international law, including jurisdiction, immunities, and the law of state responsibility, as well as international and domestic criminal law. Among the speakers today, we also have Antonios Zanakopoulos, who is also Associate Professor of Public International Law and Associate Professor of Public International Law at the Faculty of Law and Fellow in Law at St. Anne's College. He has taught as a visitor at the universities of Paris, Angers, London's King's College, Athens, Bern, Jerusalem, and Interdisciplinary Center in Herzliya, and at the China University of Political Science and Law in Beijing. He was previously lecturer in international law at University College London and at the University of Glasgow. Among the speakers, we have also Professor Regina Valutite, who is Vice Rector of the Mykolas Riomeris University here in Vilnius. And her field of research also includes international civil aviation law and state responsibility. And the last speaker we have here today is Professor Eustina Zilinskas, Professor of International Humanitarian Law, first of all, of International Humanitarian Law, but also in general of Public International Law, also in Vilnius and Mykolas Riomeris University. And he is also a member of International Fact-Finding Commission and also published a number of various articles in the field of international humanitarian law. So I expect that we'll have very interesting and fruitful discussion, including alleged or possible violations of legal instruments, international legal instruments covering international civil aviation. Also related issues of state jurisdiction, of state responsibility, but as well, I think sometimes it's should be considered as even more important, the issue of possible commission of crimes against humanity, which includes persecution of people on political grounds. Although I am pleased now to invite and give the floor to the first speaker, Associate Professor Miles Jackson. Please, the floor is yours.
Thank you very much for that introduction, Denis. And we are grateful for Professor Dovile Sagatiene's putting this together so quickly. In my remarks, I will say a little bit about the incident itself as reported, the Chicago Convention, and then the Montreal Convention. Thus, to start with the incident itself, as to the facts, I won't go into too much detail, as I'm sure they are familiar, but for our purposes, the key issues are as follows. First, on the 24th of May, a regularly scheduled Ryanair flight from Athens to Vilnius was diverted to land in Minsk on the command of Belarusian authorities. Second, a senior Belarusian Air Force commander stated that a decision was made to scramble a MiG-29 fighter jet after learning of a bomb threat. And third, it is now clear that there was no bomb on the plane and almost certainly no real bomb threat. Rather, the aim of the diversion was to arrest Roman Protasevich, a journalist and opposition activist. What does international law have to say about these events? For one, it has quite a lot to say about the treatment of journalists and opposition leaders, of detention and inhuman treatment and other human rights violations. That will not be our focus today, or at least my focus, and I will focus predominantly on questions of civil aviation. I will start with the Chicago Convention. The Chicago Convention, drafted in 1944, provides the foundation for civil aviation and establishes the International Civil Aviation Organization, or ICAO. The Convention strikes a balance between the interests of state sovereignty, recognized in Article 1 of the Convention as entailing complete and exclusive sovereignty over airspace, and the ambition to develop what the preamble calls safe and orderly civil aviation. In striking that balance, the Convention and customary international law delimit the extent of states' powers in relation to civil aircraft flying over their territory, and anticipates the agreement of numerous bilateral and multilateral treaties that govern civil aviation. For our purposes, an important starting point is 3 bis of the Convention. In addition to referring to the United Nations Charter rules on the prohibition on the use of force, 3 bis A provides, and I'll quote, "The contracting states recognize that every state must refrain from resorting to the use of weapons against civil aircraft in flight, and that in cases of interception, the lives of persons on board and the safety of the aircraft must not be endangered." Article 3 bis B then sets out 2 situations in which a state is entitled to require landing. First, if the aircraft is flying over territory without authority. And second, if there are reasonable grounds to conclude that it, the aircraft, is being used for any purpose inconsistent with the Convention. To this, we might add 2 points set out in Annex 2 to the Chicago Convention as promulgated by ICAO. First, Annex 2 proposes that interceptions of civil aircraft are, in all cases, potentially hazardous or dangerous. And second, interception of civil aircraft should be avoided and should be undertaken only as a last resort. So how do these considerations play out in the present case? In relation to the first situation, there's no reason to suggest that the aircraft was flying without authority. In relation to the second situation, to reiterate, the test is whether there are reasonable grounds to conclude that the aircraft was being used for any purpose inconsistent with the Convention. Is this condition met given the presence of someone wanted by the territorial state? The answer is no, certainly no. The presence of someone wanted by a state on a civilian aircraft is certainly not use inconsistent with the purposes. That then is the Chicago Convention, the basic framework. The second convention in play is the Montreal Convention of 1971, or to give it its full name, the Convention for the Suppression of Unlawful Acts against the Safety of Civil Aviation. This, as the name suggests, is a suppression convention aimed at deterring certain wrongful acts by requiring states to establish their criminal jurisdiction over those acts. Article 1 of the Convention defines those offenses against civil aviation, and includes in paragraph 1E, any person commits an offense if he unlawfully and intentionally communicates information which he knows to be false, thereby endangering the safety of an aircraft in flight. On the facts reported, it seems clear that this offense, under Article 1 of the Montreal Convention, was committed. Given the ulterior motive for the diversion, we can reasonably assume that the information communicated was knowingly false and thus endangered the safety of the aircraft. What then about responsibility for the diversion and for this communication of false information, assuming, as I've just said, that an offense was committed under the Montreal Convention? Let me start with Belarus, the state itself, and then the individuals. Article 10 of the Convention provides that contracting states shall, in accordance with international and national law, endeavor to take all practical measures for the purpose of preventing the offenses mentioned in Article 1. It seems clear that the state breached this duty. One straightforward way to fail to prevent the offenses in Article 1 is to commit them. What then about the individuals concerned? As I said a minute ago, this is a suppression convention. It requires contracting states to establish their criminal jurisdiction over these offenses in certain situations. The question is then when? Article 5.1 is the relevant provision, and it provides, each contracting state shall take such measures as may be necessary to establish its jurisdiction over the offenses in the following cases. A, when the offense is committed in the territory of that state. And B, when the offense is committed against or on board an aircraft registered to that state. The relevant state under 5.1a is Belarus, and it has an obligation. Under 5.1b, it was reported that the aircraft is registered in Poland. And on that basis, assuming Poland has implemented the convention in full, those who communicated the false information will bear criminal responsibility in Poland. Depending on domestic specificities, that responsibility would include those who ordered the communication. I'll stop there. That's the basic framework for thinking about the international law issues, and I look forward to discussing it.
Thank you very much. I think it's a very good beginning from a few conventions on international and safety of international civil aviation, and I think it's only logical to continue with the next speaker, Professor Regina Valutite. So please, do you agree with everything what has been said? What can you add on the civil aviation instruments applicable here? So please, the floor is yours.
Thank you very much. Well, in particular, first of all, to Professor Jackson for a very good introduction. And in particular, I would like to elaborate in particular on Chicago Convention, and not only on Article 3 bis, but also on Article 4, which usually in these kind of instances, well, at least similar, since it's unprecedented instance that we are dealing with here, is usually forgotten and not elaborated further. So, just to start from, I would like to also maybe emphasize that there are also suggestions, apart from what has been told now, that the use of military jets was also kind of the threat to use can be considered as the threat to use the weapon against civil aviation. So I would like to also, and it was improportionate given the circumstances, that there was kind of false information, possibly false information on the explosives on the plane. So I would like to elaborate a little bit on this issue, and also I would like to give more attention to what does it mean, what are the purposes inconsistent with the aims of the convention, and to think of what could be future possible developments, taking into account the lessons of this incident, because we are very much looking for the future after every incident on how the aviation law will evolve. Since we know and we say, well, luckily it was not the case, then aviation law is written in blood, and usually, well, all the developments they occur after the incidents. So first of all, as was very correctly mentioned, there is a provision saying that the contracting states recognize that every state in the exercise of its sovereignty is entitled to require the landing at some designated airport of a civil aircraft flying above its territory without authority, which was not the case here, or if there are reasonable grounds to conclude that it's being used against inconsistently with the aims of this convention. So, and here I would like just to point out that after 9/11, there has been, I would say, military jets have been increasingly used for civil aviation, for monitoring, if I may so, civil aviation in various occasions. And these terms that were mentioned in Annex 2 of adopted by ICAO, that the military interception should be used as the last resort, was interpreted quite widely. So, for instance, if there is a loss of communication with the civil aircraft, and the air traffic control cannot establish the communication, so it's very likely that the military jets will be used in order to make sure that that the plane is not hijacked or is not used for any other purposes that would be inconsistent with civil aviation. So, for civil aviation, interception is not something which is unknown. So the pilots are trained, and they know very well the procedure which is established in Annex 2. So if we, let's say, given the circumstances, let's come back to the circumstances that we have in this case. So, in case if there is an information that there might be an explosive on the plane, so it's quite, I would say, it's sure that the military jets will be sent to make sure that the jet will be escorted to the nearest airport. So, and we know from the aviation law that the decision should be made by the pilot. So if we take this situation alone, so that would be, we would not see any issue in application of Article 3 bis. Now, if we think broader, and this was also the question raised by professors that we have here in the comment. So the question a little bit wider. So how do we deal generally with the situation if we have a criminal on board? So would it be something which we would consider as inconsistent with the aims of the convention? So, and eventually what we see in this situation, so that the ultimate aim of this operation was the detention of the person and not really, well, most likely not eliminating the threat such as false, well, a possible explosives on the plane. So, and here there is the question, so whether this article could serve as the basis for landing, for the first landing, if we have a person on the plane, and also we have a lot of other instances that we would consider given the regulation that we have now in the aviation, such, for instance, the threats like if the authorities establish that there are some, that the plane, for instance, transports illegal drugs, drugs, or for instance, there is they transport biological weapon or other let's say, for instance, nuclear weapon, which is now prohibited by the Beijing Convention of 2010. So there are numerous instances that we consider as such as the threats to civil aviation. So, and there is a question way broader than the question that we have just about the criminal. So when the plane can be intercepted and when there can be the forced landing. So, well, this brings me to the point, of course, of how we should interpret Article 3 bis. And for this purpose, I would look at of course, I would use the tools provided by Vienna Convention on International Treaties, and I would look to the preparatory works on how this provision was interpreted back when it was constructed back in 1984. So we know that Article bis appeared as an article, as the provision after the incident of CAL 007, when a civilian plane of Korean Airlines was flying, was diverted from the course, and it was shot down in the territory of Soviet Union. So this is how Article 3 bis occurred. And we have it now, we say that it's part already of the customary law. And if we have a look of what kind of meaning the states wanted to attach to this article, so we can see to this, particularly the phrase of the purpose is inconsistent with the aims of the convention, we see that this interpretation was way broader than we would understand. So the parties were referring to the various, let's say, various unaccepted use of civil aviation, such, for instance, as military reconnaissance or violations of mandatory laws or requirements for state security, engaging in provocative activities, acts of espionage and aggression, transportation of narcotic guns and ammunition. So it was interpreted quite widely. So I think that after this incident, we should, and this incident will still provoke the discussion of whether having a single criminal on the plane would be the basis, would be this kind of course that we would, or incident that we can treat as inconsistent with the aims of convention, which is less likely given still quite restrictive examples that were given by the states in general in Assembly of ICAO when this article was discussed. So this is one aspect that I wanted to elaborate, since it's very important also for the future of aviation that we agree. Not limiting ourselves to this one unprecedented incident where we had let's say a person who was considered as a criminal in one country, and the aim was to detain him, but to look a little bit broader to how we understand this provision, and in other words, whether the right, the freedom, the first freedom to overfly the territory can be interrupted in one or other way. And the second aspect that I wanted to make was on Article 4, which is, as I mentioned, and as Professor Wilde mentioned a decade ago, that Article 4, which is was rather unused in the history of civil aviation, because whenever we talk about these kind of incidences, we refer to Article bis, 3 bis, because usually this is this is the legal basis that we use to intercept the civilian plane. So an Article 4, I will read, says each contracting state agrees not to use civil aviation for any purpose inconsistent with the aims of this convention. So, and it's a kind of a general provision, but since it is a general provision, so people would look just for more precise maybe provisions to understand, to qualify the situation. But what does this provision say? And the question is, like, if we can apply this provision in this case, which would be, from my perspective, maybe even less difficult to prove the violation. So the first issue is like, there is no common agreement on the content of this provision, and this is accepted by various commentators. So since it has not widely been used, there was no kind of clear explanation given on what this provision says. But historically, it was rather referenced as the provision related to the state of the aircraft more than the overflown state. So saying that the state of aircraft may not use civil aviation for any purpose inconsistent of the aims of the convention. So for instance, not using civil planes for espionage as such, for military purposes. But if we read the language of Article 4, so nobody prevents us from interpreting it wider, so because the article says that each contracting state agrees not to use civil aviation for any purposes inconsistent with the convention. So that's one point. And then the second point, so if we have a look at how this inconsistent with the aims of the convention, this construction was interpreted back when this article was constructed. So we are going back now in 1944. So basically, at that time, it seems that there was a kind of very narrow interpretation of this inconsistency, encompassing general threats to the nations, so general threats of security of the nations. And we see that exactly the same construction is interpreted already differently in Article 3 bis. So as I mentioned, so various acts that would be contrary to the civil aviation. So I would, given from the perspective, from today's perspective, and also from the late interpretation given to Article 3 bis, so I would give I would give a wider interpretation to Article 4, and I would really encourage to look at this article also as the possible legal basis for, for responsibility of Belarus as the state, if these facts that it was the fake information on the explosives on the plane came as planned action on behalf of the state. So these are my insights based on Article 3 bis and 4, and I'm also looking very much for the discussion. Thank you.
Thank you very much for this nice continuation of our discussion. Now we have, at least when speaking about Chicago Convention, one more article which actually deserved less attention in public discussions, among lawyers. And now I am pleased to give the floor to the next speaker, Professor Antonios Tsakonopoulos. But I don't know whether this question can be answered by you or by the previous speakers, but we have also questions. I see it from the audience, and I can summarize this question in a manner like that. It's quite complicated formulation, but anyway, we should be clear on one issue, I think, in this discussion. Whether the only presence of certain person who is persecuted by the Belarus authorities or by the authorities of a state in which transit takes place. Now we shouldn't maybe deal with the issue whether he or she is persecuted legally or illegally, whether the authorities are legal who instigated this persecution, but whether the very presence of such a person can be understood as a sufficient ground to intercept the flight and to force it to land and to detain this person. Because I see that namely this question now we have, and if you could elaborate also on this point, it would be very welcome. So please, Professor Antonios Tsakonopoulos.
Thank you very much, Dennis, and thanks to the colleagues in Mykolas Romeris University for organizing this and for having invited us to speak. I wasn't planning on covering this because I think it's already covered by Miles. I think it is clear that our opinion is that the presence of someone who is being charged with a crime or anything like that on board civilian aircraft is not adequate reason for diverting the aircraft and forcing it to land. It does not constitute a use of civil aviation that is contrary to the aims of the convention. I think that's what Miles said, and I think that Regina also agreed with that. And I think that's clear. I mean, in a way, it would be a rather implausible interpretation of the convention to say that whenever someone who is charged with a crime is on board a civilian aircraft overflying the territory of the state that has charged them with a crime, then they can be downed, because the next thing you know, if you did something like this, is half of the aircraft overflying any state would be diverted and forced to land because there would be someone on board who was being charged with a crime. The more important thing, I think, is that considering this as a justification does not make sense on our part, because this is not the justification that Belarus is putting forward. So for us to be making up a justification as to why Belarus decided to force the aircraft to land is not very helpful. What Belarus is saying is, we decided to divert and force the aircraft to land because we received a credible threat. So we had good grounds to believe that this was being used contrary to the purposes of the convention. Why? Because there was a bomb on board and we had credible information that this was the case. Now that remains for Belarus to prove. But I think it has become quite clear that, well, it is very clear that there was no bomb on board. Now the credibility of the claim, that remains to be proved by Belarus in that sense. If they can't prove that and they decide to say the use that was contrary to the purposes of civil aviation was the fact that there was somebody on board who we have charged with crimes or who we consider a terrorist, then we could consider that justification. But that justification hasn't been put forward. And I think that it is important for us to also remember that. But even if it were, I don't think it would work. But essentially, what I wanted to focus on is sort of Miles and Regina have covered all the substantive bases very well. And I have to say that I also agree with Regina regarding Article 4. And in fact, in our first draft of the post that we published with Miles, we had included a reference to Article 4. So we're very much in agreement with you, I think, Regina, that this can be, that the implication is that you're thinking about this article as referring to the state of registration of the aircraft, but that a wider interpretation is absolutely not precluded by the language of the provision, and that, in fact, that would be a very good interpretation of that provision, because after all, the state who's using civil aviation is not just the state of registration of the aircraft, but also the state being overflown, and they can misuse civil aviation, even though by harassing or interfering with the flight of an aircraft registered to another state. I mean, by all means. So if we've covered those bases, and we've determined that in all likelihood there have been violations here on the part of Belarus, which is, I mean, it's always depends on sort of like clarifying the facts. But as far as we know, and given the facts that are at hand and have been reported, as Miles and Regina have said, it appears very likely that we have a violation of Article 3 bis of the Chicago Convention, potentially a violation of Article 4. We definitely have a violation of Article 10 of the Montreal Convention, and so on. Now the question is, so what? Okay, so there have been violations, and what happens next? So for that, we need to look at the invocation and implementation of state responsibility, the responsibility of Belarus for the violations of those provisions. I'm not going to go into establishing that state responsibility in detail. I think it's very clear that the relevant acts are attributable to Belarus. It's all state organs that have communicated with the aircraft, that have diverted the aircraft. I mean, there's a use of a military jet to intercept the aircraft and lead it to land, and so on and so forth. So these are all acts attributable to Belarus, and as we said, they are in violation of at least some international obligations under the Chicago Convention and the Montreal Convention, which means that Belarus is now under an obligation to seize the wrongful act if it is continuing. But of course, it depends on what we consider the wrongful act. Now, I mean, these are completed wrongful acts as far as the diversion and the forced landing is concerned. But if we consider sort of the detention of the relevant person to also be part of that wrongful act, then there would be an obligation of cessation of that, an obligation to offer assurances and guarantees of non-repetition of such acts, and an obligation to offer reparation for the injury caused. And so the more important question is, who can ask for these things now? So who is it that can turn to Belarus and demand that Belarus comply with those secondary obligations? And our argument in the post is obviously the directly injured state can do so, what we call the Article 42 state under the Articles on State Responsibility, which in the cases of both Chicago and Montreal are certainly the state of registration of the aircraft, which has been reported to be Poland. But it may also be the state of registration or incorporation of the company, which is Ryanair, and potentially the states of nationalities of the passengers on board, essentially through means of diplomatic protection. So that gives you a number of states that could be sort of considered directly injured by the breaches of Belarus and be able to invoke its responsibility. I think the more important argument on our end is that we think that all other states parties to these conventions, that means the Montreal Convention, the Chicago Convention, can also invoke the responsibility of Belarus in this particular instance. And this is because we argue that the obligations, the relevant obligations under Article 10 of the Montreal Convention and under Articles 3 and potentially also 4 of the Chicago Convention are obligations that are owed erga omnes partes. That means they are obligations established in the collective interest of all the states parties to these particular treaties. And for that reason, they can be invoked by all the states parties to the particular treaties as states other than the injured state, in the words of Article 48 of the Articles on State Responsibility. Now, this is not a claim that we make lightly. I mean, it's easy to say something is an obligation erga omnes partes or is established in the interest of the group. We do believe that there is a requirement to find some anchoring in the text of the treaty to argue that a particular obligation in the treaty is owed to all the parties to the treaty at the same time. It is established in the collective interest of the parties to the treaty. And for the Montreal Convention, we think this is the case because of the establishment of an obligation to extradite or prosecute, or this aut dedere aut judicare principle, which basically demonstrates that the whole point of the convention is to cast a net over all the states parties from which perpetrators will not be able to escape. They will either have to be extradited or prosecuted. And so the idea is to secure implementation in all the states parties in a uniform manner. And that must mean that the obligations imposed by the convention, or at least some of the obligations imposed by the convention, and especially the obligation to seek to prevent the offenses, must be owed not to a particular state in each and every case, but to all the other member states parties to the convention. For the Chicago Convention, we think it's even easier to establish, at least for 3 bis, but probably also for 4, the erga omnes partes character of the obligation, the fact that the obligation is established in the collective interest, because in the final analysis, I mean, Article 3 bis is but a partial implementation or a partial reflection, let's just put it this way, of the prohibition of the use of force, of the threat or use of force in Article 2, paragraph 4 of the UN Charter and customary international law. And this is certainly an obligation that is owed to the international community as a whole. In fact, 3 bis is actually broader than that, but it is a partial reflection of that provision, which is considered to be owed to the international community as a whole. So certainly the obligation in the Chicago Convention must be seen under 3 bis, must be seen as being owed to the states, to all the states parties. They have been established in the interest of all the states parties to the convention. Now that tells us who can invoke. And in fact, if that argument is correct, essentially everyone can invoke. Lithuania can invoke as a state other than the injured state. Poland can invoke as an injured state, as the state of registration. Greece can invoke, for that matter, as a state other than the injured state, and so on and so forth. So literally almost every state in the world, because these are very widely ratified conventions, could make claims against Belarus for these violations. Now, the problem is that you know, claims can be made at the diplomatic level, of course, but is there any compulsory settlement at play? And unfortunately, there is no route to compulsory settlement of any potential disputes, of any claims that may be brought under the Montreal Convention, because even though the Montreal Convention provides for resort to the International Court of Justice, the relevant provision allows reservations, and Belarus has already entered a reservation a long time ago to that provision. So the route to the International Court of Justice under the Montreal Convention is closed. However, under the Chicago Convention, there remains a route which might end up in the final analysis before the International Court of Justice, and that's the provision of Article 84. And according to Article 84, if there's any disagreement as to the interpretation or application of the Chicago Convention, then any state party can bring the matter to the ICAO Council. And then there is the ability to appeal any decision of the ICAO Council to the ICJ. So the route to the ICJ is open. Now, the interesting thing here is the following, that there may be claims that are made. So one way for this would be to say, I don't know, whether Poland or Lithuania or Greece or whoever, the United States or whoever might have an interest to actually bring a claim against Belarus before the ICAO Council. And then have this appeal to the International Court of Justice potentially. But the interesting thing that can happen is that there appears to be states that have already made claims against Belarus for violations of the relevant treaties and have proceeded to determine that Belarus is responsible, and have also taken measures against Belarus, some of which are potentially breaches of international obligations in themselves, in response to the breaches by Belarus. So essentially to be taking countermeasures. The EU has already sort of told states to avoid Belarusian airspace and so on and so forth. There are certain measures being taken against the Belarusian national carrier and so on. So these are potentially breaches in themselves and may be justified as countermeasures, as reactions to the internationally wrongful act by Belarus. But of course, the interesting thing that can happen now is if Belarus considers that any of these measures are in breach of the Chicago Convention, then it may be Belarus that brings a claim against all sorts of other states before the ICAO Council, which can then be appealed to the International Court of Justice. And in fact, this has happened in the sense that Qatar, you will have heard this, sort of reacted to the closing down of its airspace by Saudi Arabia, by the United Arab Emirates and other states, by bringing claims to the ICAO Council, which decided to entertain those claims. It decided that that it had jurisdiction over those claims and that the claims were admissible, upon which Saudi Arabia and the United Arab Emirates sort of like appealed the decision of the ICAO Council as to jurisdiction to the ICJ. And the ICJ basically confirmed that the ICAO Council has jurisdiction. So the matter is now still with the ICAO Council with respect to its substance, and we have to wait and see how that will play out. And we also have to wait and see whether either any other state or Belarus will take up matters under the Chicago Convention to the ICAO Council, which would be interesting. I mean, it's been a very long time since we had aerial incidents being discussed or decisions of the ICAO Council being discussed in the ICJ. And now it seems we don't have just one, but potentially two coming up. So this is sort of like the really interesting aspect. I'll stop here because I don't want to take any more time, but I'm sure there's going to be enough questions for us to discuss with respect to reactions to Belarus and all that. So thank you very much.
Thank you very much for this very detailed analysis of the possible ways how responsibility can be invoked and which instruments can be used, most probably the ICAO Council at the very beginning. And now from the issues of invoking responsibility under international law, we move also to issues of the state jurisdiction under national criminal law, I think, and also to the issue I mentioned before, how can we assess very detention or arrest of those who had been arrested by the Belarus current authorities. So I'm pleased to give the floor to Professor Eustina Zilinskas. Please, the floor is yours.
Thank you very much, and it's a great pleasure for me to listen to those deep insights of my colleagues. And indeed, the case is in a way extraordinary, and it not only concerns those issues that were discussed regarding the breaches of civil aviation rules and some others, but also from the point of view of other point of view. So first of all, let's say Antonio and Miles and Regina spoke about the state's responsibility. But definitely, if we have a breach, so someone is behind the breach in flesh and blood. So basically, there are persons who are also responsible, and it's also an interesting issue. And international community, as well as lawyers of different kind, are also considering this issue and, well, discussing possibilities how to establish criminal responsibility of persons who are engaged in this situation. For example, those who transferred the message, fake message about the improvised explosive device on board and things like that. And these proposals are varying from national investigations up to International Criminal Court investigations. Just recently, I read a message that one of the non-governmental organizations have asked the International Criminal Court to start investigation into this issue. And even though the perspective of such investigation is rather cloudy, I should say, because when we are dealing with the security of international aviation, it's very, very complicated to put it in the terms of international criminal law in a way that International Criminal Court deals, because International Criminal Court deals, as everybody knows, with war crimes, crimes against humanity, and genocide and aggression and things like that. So. But here we have also interesting points in national investigation. So I'd like a little bit to cover together national landscape. And for a time being, as far as my knowledge permits, I know that Lithuania has started national investigations and Poland has started national investigations. There was something from the Greece, but I didn't understood whether it was just a political statement that Greece consider this as a state-sponsored hijacking or piracy, or was it also a national investigation started? So from the point of view of the national investigation, is definitely the main question here comes with the convention that already was numerous times mentioned, the Montreal Convention, related to the safety of civil aviation, and also the seizure of the aircraft and all the related issues. So basically, as Miles pointed out in Article 1, Convention provides that if person communicates information which he knows to be false, thereby endangering the safety of the aircraft flight, that person is committing crime. Lithuania has started its investigation in two directions. The first direction is indeed the seizure or hijacking of the aircraft. Also, second direction that I will talk a little bit later, it's a crime, it's an enforced disappearance of the persons. But I will come to this later. So Lithuanian Criminal Code indeed has an article on seizure of the aircraft. But the problem is with this article that this article, in its wording, it just speaks about the hijacking of the aircraft, vessel, or platform on the continental shelf. So they are putting a lot of conventions into this article. And even though Lithuania is a party to Montreal Convention, and already for quite some time, it is quite complicated whether we can read this wording of Lithuanian Criminal Code that hijacking an aircraft, that it would also entail this part of Montreal Convention that speaks specifically about the communicating false information. So this is the first problem that I see with our national investigation. It looks like that, well, and unfortunately sometimes it happens when the national jurisdictions are putting codifying international rules, sometimes they are missing fine points, and then when we have a problem, then we have not only problem with the international treaties, but also with national implementation. Second thing that's also quite interesting, as Miles and Antonios proposed, from the point of view of state responsibility, any state may bring a claim if we stick to the erga omnes obligations, or let's say audere aut judicare at least. So almost every state can bring a claim in the situation against Belarus. But for example, if you would be able to establish the person who provided fake information or who organized the landing of the aircraft and things like that, the problem is also in the Montreal Convention that regarding the establishment of jurisdiction against individual, it first of all provides for the subparagraph of Article 1A, B, and C. And that's quite strange. Subparagraphs D and E are not included in the Article 5 of the Montreal Convention. So in that case, there is also a question whether the other states, while implementing Montreal Convention in their own legislation, did this. So they included this specific type of the Article 1, so communication of information that knows to be false, into their national law. So in the case of Lithuania, as I said, here we have a problem. In the case of Poland, I don't know, because there is not enough details to know under which articles they started the investigation. So this is regarding the plane itself. The second issue, as we already discussed, there was an arrest of Roman Protasevich and Sofia Sapiega. The one is Belarusian citizen, the second one is Russian citizen. So here is also a few important points. First of all, Lithuania has started its investigation from the point of view of Article 100 prim of Lithuanian Criminal Code that provides for enforced disappearance of the persons. And again, those who are acquainted with the international criminal law perhaps know that the definition of enforced disappearance of the person is that when the person is taken away and there is no knowledge where such person resides, is kept, and it also entails all the network that was considered with the capturing of the person, with keeping person. So basically, these were the crimes that are very common to, let's say, South American dictatorships in the 70s, in the 80s, and so on. Here we also, by the way, Belarus is quite famous for enforced disappearance of persons while dealing with the political opponents. And I guess up to now, from the early ruling years of Lukashenko, there are still persons who are missing. And that's exactly the case of enforced disappearance in Belarus. But with the Roman and Sofia, I think enforced disappearance is not applicable. And I understand that our prosecutor's office were doing in a nick of time, so they were under pressure to start something, to start to collect evidence and so on. But perhaps the way, the avenue that it might be also chosen in this way is indeed a crimes against humanity, or the Article 100 in our criminal code. And that why we are talking about this. Well, the arrest of Roman Protasevich and Sofia Sapega is not, and well, the event by itself is unique, of course, downing the aircraft, arresting person, and so on. But what is going on in Belarus, I guess all of us more or less know that there is a overall crack against political opposition. And we have a lot of reports about the torture, about the gross misbehavior of law authorities and things like that. So in this case, Roman Protasevich and his girlfriend situation, it goes into the general landscape of crimes against humanity that, well, at least to my opinion, are going on in Belarus. So in that case, his arrest and apprehension is already on the different level. It's not just apprehension of, let's say, a criminal. If we would consider him criminal, of course, from the Belarusian point of view, he is a criminal. But let's say, and that separates this case, let's say, from the cases of Alvarez Machain, that is, for international law as well known. Or so in that case, we are dealing with a crime when the political persecution is taken to another level. And that's why I guess perhaps our prosecutor's office will change the qualification. And in comparison with the problem with the implementation of Montreal Convention that I mentioned, there is no such problem in our criminal code with the crimes against humanity. And first of all, because crimes against humanity have a clear standing both in national and international law, that jurisdiction is universal without any doubts. So in that case, this avenue, if it chosen, so it will do, I think, the right way. So perhaps one more thing that I would like to add to my observation, it's this point that also was mentioned by Antonios, that indeed we have this strange duality of the situation, that Belarus actually is not claiming that they were intending to arrest that person. But even if they are not intending to arrest that person, this arrest does not become legal because of that. So basically, we have here a couple of breaches that are going together, and well, that's the task of the lawyers to unwind it and to put in the qualification shelves, if I may say like this. So thank you very much, and I'm also looking forward for discussion.
Thank you very much indeed for this also very detailed analysis on both the issues of jurisdiction and crimes against the safety of civil aviation, but as well also including the possibility of criminal responsibility for the crimes against humanity. And so far we have one question, maybe for all the speakers or any of you. The question sounds that what's about justifying countermeasures on the basis of Article 60, paragraph 2c of the Vienna Convention on the Law of Treaties in this case. I mean, here suspension of the treaty by any party who can feel injured. So what do you think? I think the offer of this question get in mind the possibility to suspend most probably the Chicago Convention on International Civil Aviation. I mean, suspend the in the relations with the Republic of Belarus. So I don't know. The floor is open. So who of you can answer?
I think that would be a very bad idea. There are much better ideas than, you don't need to go to the treaty reactions here. There are, I mean, usually what happens is, yes, okay, the possibility is there. If you argue a material breach, then you can go to suspension or termination. But I mean, this is absolutely super extreme. It's not the practice usually, and it's not what the states seem to be doing in the instance. They're going to sort of more general either retortions or countermeasures outside the treaty framework, because the treaty framework sort of limits you to sort of reciprocal hits under the treaty, which is really not what you want to do here. I mean, the last thing you want to do is to say, oh, we suspend the Chicago Convention or we suspend the Montreal Convention. I mean, how's that helpful in any way? So yes, I mean, theoretically it's open if you can show a material breach. It's also far more demanding than resort to more general countermeasures, because it's not talking about just a breach, it's talking about a material breach and so on and so forth. It is open to argue, but I don't think it's helpful.
So I don't know if I may add to this. So recalling just the aviation history, I think that if we could talk about the suspension of the treaty, so we could talk only in here in the situation about suspension of bilateral agreements with Belarus and other countries on air services provisions. So that means that, so that would be the bilateral treaty that would describe how the scheduled and non-scheduled, well, basically scheduled air transportation should be conducted. So, which, well, I cannot recall the state at the moment, but what I have what can recall from the public information, that one of the states have already resorted to this measure. So that means that it's a very targeted measure. So, and it also well, relates only to bilateral agreements between the states, and in particular bilateral agreements on the air service provision. So that what has happened in aviation history when we had, you know, bombings of the aircrafts and some other, you know, specific violations of Hague Convention or Montreal Convention.
Okay, thank you. So if to continue this question, I mean, maybe also Professor Regina Valutita. So now we have certain measures, I mean, applied both by, including Lithuania, not only banning the flights from Belarus or transit, I mean, not allowing arrival of flights which are being conducted through Belarus. So would it also mean that these measures can be, I don't know, assessed as countermeasures in bilateral relations under bilateral agreements?
Well, generally speaking, when we talk about the countermeasures or the widely known as sanctions, so well, definitely. So I think that, well, there are 2 points here maybe. So one point is that we also see the bilateral, well, the countermeasures that are individual countermeasures, so taken by individual states. And well, secondly, if we think of what can be an effective reaction from international community, so I would only think of the countermeasures such as sanctions. So and here I would also like to refer to the history of aviation. And so if we think of how many disputes have been dealt before ICAO, before International Court of Justice, so we can count on our fingers. So because it's quite unlikely, as it was mentioned by Professor Tsanakopoulos, so that we will have any legal venue to decide the dispute, which in this particular situation could be a cow. But well, usually these disputes stop at the level of kind of negotiations and you know, trying to find some kind of solutions for still ensuring effective civil aviation. Well, here I would say that the most effective way to kind of react would be to continue applying sanctions, basically closing the European skies for the Belarusian aircrafts, and not flying over the territory of Belarus. So, well, why I say that this is the most effective? So, because of course it has the biggest financial implications, economic implications on the country. Of course, I mean, it has a negative effect. It has a negative effect because it's not a targeted, these are not targeted sanctions. So that means that they affect by basically people who live in Belarus. So they wouldn't affect a lot the passengers that use, you know, other airlines and that you know, come from other countries than Belarus, but they would definitely have the impact inside the country. So, you know, very, I would say, very broadly and generally about this question.
Okay, thank you very much. And the question, next question, maybe it's more general, again, for any of you. I think we dealt with the possibilities to invoke responsibility under, you know, the ICAO Convention or in the ICAO Council. Do we have anything else? Actually, what about International Criminal Court, for example, if we speak about crimes against humanity? What about any, I don't know, international investigation committees under the conventions prohibiting torture? I don't know. So maybe somebody can elaborate a little bit also on this issue. Because, you know, we can speak a lot about violations, breaches, but what's next? So do we again face the problem of, let's say, effectiveness of international law in this case? So I don't know, the floor is open. Yes, please, Eustina.
So yes, this problem of effectiveness is always a problem for the international law, as we all know. And but from the point of view of International Criminal Court, indeed, the only possibility to put this in the level of International Criminal Court is very much limited because of the few things. First of all, Belarus is not a party to the Rome Statute, and perhaps never will be. So, and we have only very limited instances when the International Criminal Court has started, let's say, investigation into situations that refers to the non-parties to the statute. Second thing, the very material of the case. The problem here is that definitely the only way is to put everything under the umbrella of crimes against humanity. So, from the point of view of the fate of let's say, arrested journalists and all the people that suffered because of this current crackdown, and not only current but all the years through. So in that case, definitely the International Criminal Court should then establish whether it's crimes against humanity. So so this is the only avenue that is possible. basically, but I don't know how can we include this downing of the plane as itself, as such, sorry, in this framework of the crimes against humanity, except in the case that it might be one of the instances that in order to apprehend a political prisoner, the state even resorted to the forced landing of the aircraft. So maybe to show the political element, so this so-called attack against civilian population directed and so on, maybe that's the only point that could be used in such instance. But again, before this, International Criminal Court must have jurisdiction. For example, let's say Security Council perhaps also will never address the court because Belarus is supported by Russia, and Russia is permanent member, so it can veto any decision. China probably also will not support it in such situation. So I have very big doubts whether it would be possible to put under International Criminal Court. Regarding the Committee Against Torture, okay, so that would be another additional investigation, another additional avenue. But again, it will transfer totally to the different issue, to the treatment of those people that were arrested. So Roman Protasevich, he was also. It looks like from this video footage that he was at least inhumanely treated, because again, as you know, we lawyers make the difference between inhuman treatment, torture, and so on and so forth. So here is indeed a lot of problems, a lot of speculations, and for the time being, I'm very doubtful whether this avenue would work.
Thank you. Thank you, Eustinas. Indeed. Yes, please, Antonio.
If I can just add, I mean, you're mentioning effectiveness. There are very effective ways for dealing with questions under the Chicago Convention, including compulsory jurisdiction of international organs. So whatever you might want to say about international law in general, in this case, you cannot say that there are no effective ways of dealing with this. There are very effective ways of dealing with this, if we're talking about the aerial incident. But it seems that people are getting slightly confused, and they're talking about other things, like how do we change the situation in Belarus? That is not what we're talking about here, to start talking about crimes against humanity and start talking about Convention Against Torture and whatnot. This requires sort of like, and I think Eustinas did very well in sort of setting out how difficult it would be to make any claims under those under such instruments in the circumstances here. So in response to the question, I would urge whoever is asking it to think about what they have in mind. If they have in mind the aerial incident, then the facts may not be absolutely clear, but they are relatively clear. International law is pretty clear on the issue, and there are effective ways of dealing with it and effective reactions that can be taken. And in fact, some of them are already taken, and also effective avenues for dispute resolution. So that general argument about international law and effectiveness does not work here. If their issue is, we want to change the situation in Belarus, that's a different issue. And so there, the problem is not so much the law, I would remind people, because the law only gives you tools, and it gives you lots of tools to do lots of things, but it may be the fact that there is no political capital or political interest in changing certain things, or expending the political capital that is required to change certain things politically. So let's not sort of like put everything on the shoulders of international law or the effectiveness, and let's just nail them for torture or crimes against humanity, as if that's going to change anything. Change doesn't come in those ways. But anyway, it may help, but that really doesn't. Sorry, that was my general rant there.
Thank you very much. I see we have a few questions, but before that, because you mentioned that not all, of course, not all the circumstances of this aerial incident has become known so far or investigated, but one circumstances which is actually, I mean, undisputed and is well known, that at the time of interception, the plane itself was much more closer to the final destination, I mean to Vilnius, rather than to Minsk. Does this circumstance has any, I don't know, legal significance in assessing what has happened actually? Because, you know, as well as other circumstances which are also quite known, that after the forced landing, the inspection has been carried out not so fast. Evacuation was delayed. I mean, evacuation from the plane. Can you elaborate a little bit on that? What can, I don't know, what impact of this well-known circumstances could be in the general assessment of the aerial incident? Any of you, I mean, not necessarily Antonius.
I guess one thing you might say is that it helps with the inference that this was false and fake. So on the factual level, if it were an emergency and it's an airport that's closer, you might think that assists with that inference. If this had been in Lithuanian territory, then we were in a different world entirely. If a fighter jet had been deployed across the border, then we're in a different conversation entirely about international relations, but that isn't the situation. I think that's the extent of it.
I mean, perhaps one thing that we might want to keep in mind is, I fully agree with Miles. It makes the situation very suspect in those circumstances. However, if we were to sort of like play the devil's advocate, it's sometimes, so assume that everything that Belarus says is true, which is that they actually have a credible threat that there is a bomb on board. If the aircraft is in their airspace, so that means within Belarusian territory, then they actually have an obligation to make use of that, to take the aircraft to safety as quickly as possible. And it just may be that if the aircraft were to cross into Lithuanian airspace, for example, by the time that Belarus has gotten in touch with Lithuania for the Lithuanians to sort of like scramble their jets to escort the aircraft to Vilnius or something like this, this might take longer than it would take to divert the aircraft to Minsk. That is one possibility. But that just basically assumes that everything that they say is true and that they can also show that the quickest way to react to this was to divert the aircraft to Minsk. It's not beyond the realm of possibility, but there has been absolutely no convincing evidence showing that this was the case, nor has the point even been made by Belarus, to my knowledge, that this was the better and quicker and safer way out. Not to mention, of course, that they haven't backed up the bomb threat in any way. And so if you have to make a decision, you would have to go with what Miles says, which is this sounds very, very, very suspicious. But it's not in and of itself. It's not. It's just circumstantial evidence pointing to the fact that this thing is very, very fishy, rather than a breach in and of itself.
Thank you. And as I mentioned, we have a few questions. The first one, I think it's not purely legal, but we lawyers, I think, should always perceive law in a much more broader, let's say, context. As a Belarusian, I should say that it is very controversial measures, such as prohibiting the flights from Belarus. So-called president does not care a lot about it. He just came like an offending side to the Russian president. Who will really suffer? People who are locked up in the country indefinitely now, or people who cannot come back to Belarus because will not have any chances to leave it in close time. So any reflection on this issue? Because yes, indeed, all the countermeasures Usually, even international sanctions, if they are not targeted enough, can have also negative impact on the population of the state to which we address. So I don't know, general question for any of you.
So
Yes.
if I may just, again, recall some historical events. So, of course, way more serious in the circumstances they had. So we had the situation of well-known situation of Lockerbie catastrophe. So when we had Libya, Libyan government behind the explosion of the plane over the Lockerbie. So, it was a Pan-American Airlines flight. So, and indeed, I mean, there was a huge reaction. It was the explosion of the explosion of the aircraft. So, as I mentioned, so the circumstances were way wider than we have the circumstances here. But again, I mean, we had a very wide reaction from the world. I mean, we had the issue put at the table of the Security Council, and there was an issue, basically the sanctions were, heavily sanctions were applied against the economic sanctions against the country. So that, I mean, similar that we have here, additionally, there were economic sanctions. So, and indeed, I mean, what was when these sanctions were about to end and when they partially ended, when the countries could agree with Libya to extradite people who were behind, even if they were state officials. So, and that was done. And of course, the sanctions were, and then that was the point when the sanctions ended. So here again, I mean, the question is like, of course, if the sanctions are not targeted, so it's widely discussed for many years in international community that they may have the side effect, and they have direct side effect on people. But then, I mean, I think that the final point of this discussion in international community will have when we could agree on what is safe airspace, so what could be deemed a safe airspace in these kind of incidents, and then we have to kind of at least enter into negotiations, enter into discussion of the country with the country. So, and that's how international law works in a sense. So, so I mean, just a very general comment that it's not that's generally aviation law is not somehow different in terms of how sanctions are applied. So the side effect, it still remains as an issue for everybody.
Yeah, I just agree with Regina and the questioner that it's easy to think about taking sanctions, even coercive measures, coercive sanctions, and another thing to think about the impact on people and who's being impacted by it. So that should be in the conversation. Absolutely.
Thank you. And we have also the next question, which seems to be quite technical, but maybe we can try to respond to it. Does involved countries has the legal grounds to request the record of conversation between pilot and the receiving airport? Who can try to answer?
Maybe if I could say, aviation works in a way that generally, to my knowledge, all the recordings that the pilot or the cockpit pilots have with their air traffic control or anybody, I mean, or including the military jet, if there were some conversations. So we have the black boxes, and we have one of the black boxes that keeps the all the conversations that the cockpit had with the outside. So and when we have any investigation, so first of all, what we do, we just turn to these black boxes, to these recordings that give us the plausible, basically, well, if I may say so, evidences of what have happened. So, and we are really looking forward to kind of official information from these recordings, because that will be the most, I would say, credible information, because now we are getting a lot of information from the press. So on different aspects in this case, and sometimes it appears that these kind of circumstances are conflicting, and we do not know for sure what really happened. So we are looking forward for these recordings, official recordings, but for that, as far as I know, but this is maybe, this is the information that I also have from the public, so that so these recordings, they have been delivered, but the authorities here, they do not have the expertise in dealing with in making this investigation, and this is why it's still in progress. But well, generally speaking, in aviation, this is what the RAB means, to get these conversations. And since ICAO promised to have an official investigation, so I have no doubts that these kind of official recordings will reach all the relevant parties to this dispute.
Thank you very much. Yes, please, Eustinas.
Just a very short remark. As far as I know from the public knowledge, the recordings now has been transferred to Poland. And in this situation, Poland has, I should say, the strongest jurisdiction in this case to deal. And perhaps they also have the equipment and specialists needed to decode the content of the black boxes and all the other equipment. So.
Thank you very much. So far, I don't see any new questions. Maybe if I can suggest any final remarks from any of you, please. Who first? Miles, maybe.
I have no substantive remarks, just to say thanks very much for hosting and for the questions.
So if I may stick to the initial order, to be the second to make the final remarks. So I'm really looking forward as the person interested in aviation law, how the aviation law will develop, as I mentioned, after this incident, because there are certainly a number of interesting questions to be answered. And as I mentioned, after every incident, we have some kind of discussions on how to fill in the gaps in the regulation, because I still see some upcoming incidents or possible incidents that could be in a way already now precluded from the legal point of view, at least by filling in the existing legal loops. So thank you very much for this possibility. Thank you for the colleagues from Oxford University. So it has been a pleasure to talk about this incident with you.
Thank you. Next. Yes, please, Antonio.
I will only echo my colleagues in thanking everyone for organizing this. It was a great pleasure to have this discussion with our Lithuanian colleagues, and very nice to visit Mykolas Romeris University, even if only virtually. We do hope to visit you in person one day in Vilnius. So thank you very much for having us and for this really interesting discussion, which I'm sure there will be further opportunities to discuss these matters, as Regina said. So thank you very much.
So, Eustinas, please.
I also would like to thank everyone for the participation and for valuable insights. And I also would like to remind that we are very thankful for Miles and Antonios, because they were the first in the European Journal of International Law blog to write a quite extensive article on this issue. And indeed, without their initial initiative, perhaps this conversation wouldn't happen. So again, thank you very much, colleagues. And indeed, we are looking forward to meet you in Vilnius.
Or in Oxford.
Okay, or in Oxford, but you know it's Brexit. So.
So, if I may, to summarize, I would like to join all of you and thank you all for this really fruitful, informative discussion, which shed the light to, I think, a number of issues which may be not so clear for the audience here in Lithuania and broader outside Lithuania. I think that we all came to the same conclusion that, of course, although we don't know and all the circumstances, investigation hasn't been finished, but we can speak about the high probability that the Chicago Conventions, a number of Articles 3Bs, 4, and Montreal Convention had been violated by the current de facto Belarus authorities. We can also we can have the ground to speak about the crimes against humanity, or one episode, let's say, of the border crime against humanity which is going on now in Belarus. And we also talked a lot on the possibilities to invoke responsibility with maybe most efficient possibility to use the channel of ICAO Council with the perspective also of international judicial litigation. But in general, you know, what can I say? Really, we should think, we should find, I mean, we, all the international community should find the ways how to prevent and, of course, persecute, punish the similar incidents. Because what is at stake? First of all, we have at stake all the, I don't know, credibility of international civil aviation. Because if this incident goes unpunished, then for the future, it will be a very dangerous precedent to disturb and to interfere into the freedom of international civil aviation. And the next, of course, it's maybe more general issue of erga omnes obligations in the field of international humanitarian law, and more general the situation in Belarus. It is also a huge challenge for, first of all, for the European, but also for international community in general, how to stop those atrocities which are going on in Belarus. So thank you very much for the participation in this discussion. Thanks to Professors Miles Jackson, Antonios Tsanakopoulos, Professor Regina Volutita, and Professor Eustina Zilinskas. And see you all in future. Have a good evening, and see you in future. Good luck. Thank you.
Thank you.